Good morning, everyone, and welcome to our annual property update. It's fantastic to see so many of you here in person, and thank you also to all of you joining us online. You're all very welcome. So just a bit of housekeeping first. We aren't expecting any fire alarms, so if you do hear one, please follow the staff who will show you the exits. Just a reminder also, if you're in the room, to please switch off mobile phones. The seminar should last about 45 minutes today, and for those of you in the room, please do stay around and have another coffee afterwards and a chat. For those of you watching online, I'm sorry we can't offer you a pastry this morning, but please do get in touch afterwards if you've got anything you'd like to have a chat about. If anything comes up during the seminar, please do feel free to pop a question in the Q&A box online, and we'll get back to you after the seminar. So we last met in March at our spring update, and I think at that point we were reporting that we were seeing a bit of a return to transactions, but volume and speed was picking up a little bit, and we were hoping that there was going to be some more urgency. I think we weren't quite out of the woods at that point. The next few months we continued to see quite a lot of elongation to transactions. They were taking forever to get through to exchange and completion. But I think in the last couple of months, certainly, we've definitely seen a bit of a return to something like business as usual. I think with interest rates continuing to fall and inflation being pretty steady, I mean, it's been reported this morning that inflation has dropped again in September. Banks have more of an appetite for property, and there's a bit more confidence that debt is affordable. Investors have more confidence in the market, and I think that's the key thing, really. Stability is what we've all been waiting for over the last year or two. We've noticed a marked shift in transaction volume since the election in the summer, particularly in the residential development sector. The government's pledge to build 1.5 million homes over the next 5 years, coupled with the proposals to relax some of the Greenbelt rules, have meant that there's a lot more impetus to transactions and people are keen to get things going. We've also seen with new transactions, there's a lot more activity in the promotion agreement and option agreement side of things. We act for a lot of developers and promoters, but we also have a lot of landowner clients. And so we're seeing very much seeing things from both sides of the equation. We've actually had a few transactions which had been mothballed for a couple of years in some cases, come back to life with renewed traction. So that's fantastic to see, and long may it continue. The recent proposal for brownfield passports for the development of brownfield land in urban areas has also been very widely welcomed by the real estate sector, with the promise that the default answer to straightforward development proposals will be yes. You might have seen in the press yesterday that the government has allocated around £20 million to the north as part of the Brownfield Land Release Fund. Insolvencies are of course still happening in the construction sector. We saw the collapse of ISG just a few weeks ago. I think it's still a tough market for contractors. Margins are very much still being squeezed, and there's also the post-Brexit effect on labour shortages to fulfil the contracts that are in place. And I think there is a feeling that that might have a knock-on effect on what development can happen over the next few years. The big thing we're all, of course, waiting for is the autumn budget in a couple of weeks' time. There's been a flurry of activity. We've seen people want transactions to happen by the 30th of October, and everything must move for that. But on the other hand, I think new transactions that are coming online are taking a bit longer to get going, where people are sort of waiting to see just how things are going to pan out after the election. Keir Starmer has, of course, infamously said that the budget's going to be painful, but it remains to be seen what form that pain will take and how much that might affect the property market. There is, as always, lots of speculation about which taxes might be raised. A number of areas may, of course, affect the property market. Rumours of potential increase in capital gains tax, a reduction in pension tax relief, although I think the recent commentary seems to be saying that that'll either not happen or it won't be as bad as people might have feared. There's also talk of changes to inheritance tax, both potentially an increase in the rate of tax, but also a potential reduction or even removal of reliefs such as business property relief and agricultural property relief. These reliefs can be fundamental to succession planning, particularly for farming families. If that relief is removed, there's a potential need in the future to sell the land to pay inheritance tax, which will threaten the business itself. We've talked a few times over the last couple of years about whether or not the office is dead. I think it's clear that with companies like Amazon demanding a 5-day return to the office for employees, investors can be sure that the office definitely is well and truly alive. I think occupiers are still continuing to be more demanding though. They want an improved experience when they're in the office. Climate change also remains firmly on the agenda. I think the commitments made in the past are looming very quickly. The Department for Energy Security and Net Zero announced at the end of September that they're going to review the proposals for timelines on EPC regulations. So as you're probably all aware, at the moment, the regulations provide that by 2030, all commercial buildings will need to be an EPC of B at least. So we will wait to see, obviously, what happens there. I forgot to do that slide, I do apologise. That's me, hi. So, back to this morning. We'll be hearing firstly from Laura Pyle. Laura's going to talk us through some of the most important cases which have been heard this year. She'll also discuss briefly the proposed changes to legislation proposed by the new Labour government. Sarah Cohen is then going to talk in more detail about the proposed changes to the National Planning Policy Framework, the catchy title, and then look at what this might mean for landowners and development and where we can come in to help you with any opportunities that might arise. And then finally, Carly Traverse is going to talk to us about the Building Safety Act. It's obviously a very topical issue at the moment, particularly with the Grenfell Tower inquiry results having been released so recently. Carly will look at the legislation itself and who it affects, and then she will talk us through some of the impact that is having on transactions and the practicalities of dealing with a building that's covered by the Act. So firstly, I will hand over to Laura.
Thank you, Jo, and good morning, everybody. So, as Jo said, this morning I'm going to go through some of the main case law updates that have occurred in 2024. I'm also briefly going to discuss what the policies of the Labour government are likely to mean for this industry and some of the new legislation that we're expecting to come into force in the near future. So we'll start by looking at some of the recent cases. So the first case I'm going to discuss with you is Peachside Limited versus Lee and Another, which is a dilapidations matter that involves a local property in Manchester. So the defendants in this matter were the tenants of a restaurant known as Pearl City, and it was located at 33 George Street and 14 Nicholas Street in Chinatown, Manchester. And the property was part of a former textile warehouse. That slide shows a photograph of the property itself and also a map as to where it's located. So, what are the facts of this case? Well, the defendant occupied the property under a 14-year lease that expired in February 2017. The lease had the usual repairing covenant with internal and external decorating obligations on the 5th, 10th and final year of the term. The defendant had applied to renew its lease under the Landlord and Tenant Act 1954, but discontinued the proceedings, which meant that the lease terminated in November 2020. The claimant served a schedule of dilapidations in October 2020 and sought damages to compensate the claimant for the defendant's breach of its repairing obligations under the lease. Now, the claimant had sought professional advice and had been told that the property was unlettable in the state and condition it had been handed back, and that substantial works would be needed to allow it to be relet as a restaurant. The claimant was advised that the best future for the property was for it to be converted to commercial office space. As a result of the advice that had been received, the claimant decided to undertake works to the property to convert it to commercial use. And the works were carried out in 2 phases. So the first phase was to remedy the disrepair and allow the property to be relet as a shell. And if the claimant was unable to relet the property on that basis, then the second phase of the works was to create a fully lettable office space for immediate occupation. Now, the defendant was very critical of the claimant's actions and thought that the claimant was attempting to retain as much money as possible from them. And the matter was defended on the basis that some of the works were unnecessary or amounted to betterment. They also relied upon Section 18 of the Landlord and Tenant Act 1927 and argued that the claim exceeded the diminution in value of the claimant's interest that had been brought about by the disrepair. They also argued that the landlord's intentions for the property rendered the repair works valueless. Now, in this case, the judge was satisfied that the claimant's claim did not exceed the diminution in value of their interest caused by the disrepair. The judge also found that the works would not supersede the works required to remedy the disrepair. Consequently, the repairs would not be deemed to be valueless. The judge found in favour of the claimant and awarded damages in the sum of £542,671, which included loss of rent and insurance rent for the periods in which the works were carried out. Now, this case shows the importance to tenants to ensure compliance with their obligations in the lease during the term to minimise their liability at term end, but it also highlights the importance to landlords of taking professional advice at term end and prior to undertaking expensive repair works to their property to ensure that the cost of those works can be recovered and aren't caught by the statutory cap. Now, the next case I'm going to have a look at is the Tropical Zoo Limited versus the Mayor and Burgesses of Hounslow, London Borough Council. And this is an interesting case on forfeiture and the doctrine of waiver. So you're all probably familiar with the concept that you can't forfeit a lease if you waived your right to do so. So this case talks about that. So what were the facts in this case? Well, in this case, a 125-year lease of approximately 25 acres of land near Heathrow Airport was granted to the tenant by a local authority. The lease contained a tenant covenant to build a zoo and educational centre within 2 years of the lease being granted. The lease also contained a covenant to remedy any breach of a tenant covenant that has been notified by the landlord to the tenant as soon as possible and in any event within 2 months after the notice had been served. Now, that's a rare provision and it essentially allows the landlord to forfeit for a breach of covenant when it's previously waived its right to do so. So the tenant failed to construct the zoo within the 2 years, but the landlord didn't seek to forfeit the lease. The landlord simply continued to accept and demand rent. On the 6th of November 2020, the landlord served notice on the tenant requiring the breach to be remedied within 2 months, but the tenant failed to comply with that notice. Therefore, the landlord served a further notice on the 16th of February 2021 under Section 146 of the Law of Property Act 1925, requiring the breach to be remedied. The landlord asked their rental collection agency to stop demanding or accepting rent. No demands were made, but the tenant paid the rent to the agent's account until the end of 2022. All but 3 of those payments were promptly returned. On the 3rd of August 2022, the tenant issued proceedings for a declaration that the lease was not liable to be forfeited, and in the alternative for relief from forfeiture. So as a quick recap, you'll be aware that the law looks at breaches of covenants as either once and for all breaches or continuing breaches. If a landlord waives a once and for all breach, then they cannot forfeit for that breach at a later stage. Whereas if a landlord waives a continuing breach, then a new right to forfeit will arise each day, and the landlord has a fresh opportunity to forfeit for that breach. Now, when a lease requires something to be done by a certain date, as it does in this case, then it's usually categorised as a once and for all breach. So the tenant was to build the zoo building by 2014, but the landlord continued to demand and accept rent until November 2020, when they served the notice requiring the tenant to remedy the breach by January 2021. Now, in the High Court, the judge found in favour of the landlord and found that it had not waived the breach that had arisen by the tenant failing to comply with the landlord's notice that was served in November 2020. It confirmed that the drafting in the lease was effective and the landlord could forfeit the lease for a breach of that provision. Relief from forfeiture was also refused in this case. So the point to note is that the tenant covenant to remedy the breach within 2 months of receipt of a notice was a freestanding covenant, and it meant that the landlord could forfeit for the breach of that covenant itself. So going forward, it may mean that we see an attempt to have this wording incorporated into leases by landlords, as it does allow them to forfeit at a more convenient time, although tenants are obviously likely to push back on that. Now, the judgment leaves open the question as to whether parties can contract out of the doctrine of waiver, And in this case, it was found that the provisions in the lease didn't exclude the operation of waiver. In relation to the agent not returning rental payments immediately, the court found that the agent did not have full authority to manage the property and was performing a treasury function by accepting and demanding the rent. Therefore, the landlord didn't accept the payments and it didn't give any rights to a waiver of forfeiture. So, the final case that I'm going to look at this morning is QuickFit Properties Limited case, which is a case involving a commercial lease renewal. And it's only a county court case, so it's not binding, but it's still of interest nonetheless. So the facts in this case are that QuickFit brought a claim against its landlord for a renewal lease of its property at Washington, Tyne and Wear. The parties were agreeable to the new lease being granted, but there were a number of disputed terms, including whether the lease should contain a tenant's break right. The original lease was granted in 1996 for a term of 25 years with no break clause, and the parties agreed that the new lease should be for a term of 15 years, but QuickFit sought a break at years 5 and 10. QuickFit sought those provisions due to its operations being in a position of unpredictable developing change. Now, we all know that when a tenant's renewing its lease under the Landlord and Tenant Act 1954, that the court must have regard to the terms of the existing lease. And the case of O'May states that the party seeking to alter the terms has to justify the reason for the change. An example of that's often where the landlord's seeking a break right because they want to redevelop the property. And the question that the court had to consider in this case is there a realistic possibility that the tenant would need to vacate on the 5th or 10th anniversary of the term? QuickFit argued it needed flexibility in view of its operational changes and that their request reflected market practice in the industry. The court considered the evidence, which included looking at other leases in the industry, and concluded that there was no evidence that leases with 5-year breaks were market practice in the industry. However, the court found that there was evidence that the break clause would have a negative impact on the landlord's reversion. So in light of this, the judge ruled that the tenant had not been able to establish that there was a real possibility of needing to terminate the lease early because the premises were becoming unsuitable for business operation. QuickFit's desire was to retain maximum flexibility, and the judge found it was not fair or reasonable to include the tenant's break clause in the new lease. So this case really highlights the need to be able to justify why a provision should be included in the renewal lease that's different to the existing lease. And it also shows that it needs to be justified by reference to considerations that would affect the property. It can't simply be a preference for the tenant. Now, I thought I'd mention briefly about the fixed recoverable cost regime because this has come up a little bit recently in practice. So you may recall that before the 1st of October 2023, court cases were allocated to either the small claims track, fast track or multi-track, depending on the value and complexity of the claim. And each track has its own rule on costs. So, for example, on the small claims track, only nominal costs can be recovered. Now, when the fixed recoverable cost regime came into force, it covered all claims up to £100,000, and it also introduced an intermediate track, which sits between the fast track and the multi-track. And these cases on the intermediate track are divided into 4 different complexity bands, which determine what fixed costs are recoverable. Now, a number of property litigation matters can arguably fall into the intermediate track. For example, dilapidations are a very common one, and questions have arisen as to whether parties can contract out of the fixed cost regime. So, for example, there's normally a provision in a lease that the landlord relies upon to recover its legal fees. Now, the current thinking on this is that where there is a contractual right to costs in a commercial lease, and the courts will normally exercise their discretion to reflect that contractual right unless there's a good reason not to do so. Now I'm just going to go and have a look at some of the Labour government changes. So the Labour government's manifesto was to change Britain, and their plans to do this were set out in the King's Speech. So today I'm going to have a quick look at the changes to the residential property possession market with the abolition of no-fault evictions, the Leasehold and Commonhold Reform Bill, Planning and Infrastructure Bill, and reform of business tenancies. So we'll start by having a look at the abolition of no-fault evictions. So there's been discussion for some time about abolishing Section 21 notices or no-fault evictions in the residential housing sector. It was originally introduced by the Conservative Party, and the Renters Reform Bill was introduced to Parliament in May 2023. However, it was then delayed in October 2023 pending reforms to the court system. Now, the Labour government has committed to abolishing no-fault evictions, and now the Renters' Rights Bill had its first reading in the House of Commons on the 11th of September, and it's also had its second reading on the 9th of October. So what are the key proposals in the bill? Well, they're to abolish fixed-term assured tenancies and assured short-hold tenancies. So going forward, all tenancies will be periodic. It's going to abolish the no-fault evictions under Section 21 of the Housing Act. It's going to amend other grounds for possession to provide tenants with more security. For example, they'll have a 12-month protected period at the start of the tenancy where they can't be evicted for the landlord to move in or sell the property. Many of the mandatory grounds will now have a 4-month notice requirement, which is greater than the current provisions. There's also new protections for tenants who are in arrears of rent. So the mandatory threshold will increase from 2 months' rent to at least 3 months' rent, both at the time the notice is served and at the hearing. The notice period for rent arrears will also increase from 2 weeks to 4 weeks. There's new grounds for possession, including whether the landlord, their spouse, partner or family member requires the property as their own or principal home. Tenants will be able to end the tenancy by giving 2 months' notice. Landlords won't be able to unreasonably refuse a tenant's request to have a pet at the property. However, they can require pet insurance to cover the cost of any damage to the property caused by the pet. There's going to be a decent home standard where landlords can be prosecuted or receive a civil penalty for failing to address serious hazards. And they're also going to introduce a new ombudsman to provide a cost-effective way of resolving disputes, and a new database which aims to help landlords understand their obligations and provide information to tenants. So invariably, it's likely to be more difficult for landlords to obtain possession of their property going forwards, as they're going to have to demonstrate to the court that one of the grounds applies. At the minute, you can just use the Section 21 notice, where they don't have to prove any fault on the part of the tenant to gain possession. It'll also reduce the amount of control a landlord can have over their property. Some of the proposals may be concerning for investors, particularly given tenants can now serve notice to leave the property at an early stage. And the changes may also deter investment in the residential property sector and limit growth. Now, the implementation of these changes was previously delayed due to concerns about the demands on the court system. And inevitably, there's still going to be an increased demand as a result of the changes, and resourcing is still very much a concern. Now, I believe this bill is going to come into force probably spring or summer 2025, but we will keep you up to date on that. So briefly going to just have a quick look at the Leasehold and Common Hold Reform Bill. So there are plans for a draft Leasehold and Common Hold Reform Bill to be prepared, and that bill's intended to regulate ground rents under long residential leases. And through this bill, the government also proposes to remove forfeiture as a remedy for a breach of a lease, although that's only likely to be in residential and not commercial leases. But obviously, the abolition of the right for a landlord under residential leases to forfeit is going to have a significant impact on the landlord and tenant relationship if that does come into force. So the Planning and Infrastructure Bill, so that bill's intended to streamline and speed up the planning process to allow more homes to be built and to deliver on major infrastructure projects. It's also likely to reform the compulsory purchase compensation scheme. So we'll keep an eye out for that one, and we'll let you know what its proposals are when it comes out. And then finally, reform of business tenancies. So the reform of business tenancies has been discussed in recent years, and the Law Commission is promising that its consultation paper will come out this autumn. I don't know if it will, the government are quite busy at the minute, but if it does, then we will let you know what the proposals are for that as well. But thank you very much for listening. I hope you found it informative, and I'm now going to pass you over to Sarah.
Thanks, Laura. Hi, everyone. Please bear with me today. I've woken up with a horrendous cold. So if I need to sneeze, drink water, apologies. So I'm going to talk about some of the government's proposed changes to planning policies and how landowners can make the most of development opportunities. Back in July, the Housing Secretary, Angela Rayner, announced an overhaul of the National Planning Policy Framework, or the NPPF, as part of the new government's pledge to deliver 1.5 million homes over the next 5 years and get Britain building again. The NPPF sets out the government's planning policies for England and how these should be applied. It provides a framework within which locally prepared plans can provide for sufficient housing and other development in a sustainable manner. Under Labour's plans, if a local planning authority is unable to meet housing targets after considering all opportunities to make effective use of brownfield, then some low-quality greenbelt land can be freed up to become part of a new grey belt to allow new homes to be built. That consultation is now closed and the government is considering the responses. Hot on the heels of the NPPF consultation, in September, the Ministry of Housing, Communities and Local Government launched a policy paper seeking views on what further action it could take through the planning system to support the development of brownfield land in urban areas. It proposes options for a form of brownfield passport, which would set parameters about the type and form of development that would be acceptable on urban brownfield land, with default approval unless specified exclusions apply. An example of this would be a flood risk that can't be mitigated. Just yesterday, Keir Starmer announced that there will be a £68 million pot of money that will go directly to 54 councils, including Manchester. The councils will be able to use the money to turn neglected land into new homes. With the funding, which will be delivered through the Brownfield Land Release Fund, councils will be able to cover the cost of decontamination, clearing disused buildings or improving infrastructure. The government says that as a result, land will be released to enable 5,200 homes to be built across the country. So what can we expect from brownfield passports? These are designed to make it clearer that brownfield land should be the first port of call when looking at sites for development, and the development of brownfield sites should generally be considered acceptable in planning terms. MHCLG have said that making the most of urban brownfield land through the planning system should mean bringing vacant and underused brownfield sites into more productive use, identifying where existing developed land would benefit from redevelopment, intensification, or a change of use, having clear policies in place to communicate these opportunities with development proposals informed by the views of local communities, and ensuring that brownfield development contributes to making great places supporting healthy, resilient communities. The government's been clear that it isn't considering the granting of automatic planning permission on brownfield sites. Instead, it wants to explore ways of providing more clarity for development of brownfield to lower the risk, cost and uncertainty associated with securing planning permission. Turning now to grey belt, as of March 2023, 12.6% of England's land area was designated as green belt land. Under the current rules, development on land designated as green belt is regarded as inappropriate and should only be granted planning permission where very special circumstances exist. The fundamental aim of Greenbelt policy is to prevent urban sprawl by keeping land permanently open. The 5 purposes of the Greenbelt are defined in the NPPF as being 1. To check the unrestricted sprawl of large built-up areas, 2. To prevent neighbouring towns from merging into one another, 3. To assist in safeguarding the countryside from encroachment, 4. To preserve the setting and special character of historic towns, and 5. To assist in urban regeneration by encouraging the recycling of derelict and other urban land. The grey belt is a concept introduced by the Labour Party to identify poor quality, underutilised sections of the green belt. Examples that have been given are land on the edge of existing settlements or roads, as well as old petrol stations and car parks. We now have a proposed definition of grey belt land in the draft NPPF. It says, for the purposes of plan making and decision making, grey belt is defined as land in the green belt comprising previously developed land, and any other parcels and or areas of green belt land that make a limited contribution to the 5 green belt purposes, but excluding those areas or assets of particular importance listed in footnote 7 of the framework. Previously developed land is defined as being land which is or was occupied by a permanent structure, and it includes the curtilage of the developed land and any associated fixed surface infrastructure. There are exclusions, such as land occupied by agricultural or forestry buildings, and land that has been developed for minerals extraction or waste disposal by landfill, where provision for restoration has been made. Another exclusion would be land that was previously developed but where the remains of the permanent structure or fixed surface infrastructure have now blended into the landscape. Footnote 7, which is mentioned in that definition of grey belt, includes designations for environmental protection, so habitat sites, SSIs, AONBs and national parks. Labour have announced 5 golden rules for the development of any scheme built on greenbelt land. One is brownfield first. So development must look to brownfield first, prioritising the development of previously used land wherever possible. 2 is grey belt second. And within that, low quality areas of the green belt need to be prioritised over nature-rich, environmentally valuable land in the green belt. 3 is affordable homes. For schemes that involve the provision of housing, at least 50% affordable housing will be required. 4 is boosting local or national infrastructure. New public services and infrastructure such as new schools, GP surgeries and transport links must be introduced when building on the green belt to deliver well-designed, connected places. And the final one is to provide or improve existing local green spaces. Residential development schemes must provide new or improve existing local green spaces that are accessible to the public, so that residents have access to good quality green spaces within a short walk of their home. So with all this focus on house building, how can landowners unlock additional value from their land? Entering into an arrangement with a developer or promoter can be an effective way for landowners to do this, particularly if they don't have the time, experience or money to fund the promotion and planning application process themselves. Option agreements and conditional contracts are the traditional methods for developers to acquire land for development, to maximise its value and minimise some of the risks. But promotion agreements have become popular in recent times. One reason for this is that it's often difficult for developers to obtain finance to purchase development sites. An option agreement provides prospective developers with a right to buy a property on pre-agreed terms within a specified timeframe. We typically see option periods of between 2 and 5 years, subject to the usual extensions where a planning application has been submitted but not finally determined at the expiry of the original option period. Landowners can require the third party to pay an option fee in return for the landowner tying up the property for the option period. The option fee can often be a significant amount and is retained by the landowner whether the option is exercised or not. Usually the option fee is in addition to the purchase price payable for the property if the option is later exercised. The developer is usually under an obligation to try and obtain planning permission for its proposed development at its own cost and risk, but that's not always the case. Once planning permission has been obtained, it is at the developer's discretion whether they decide to exercise the option and purchase the land. If the developer walks away, the landowner will be left in a position where it has sterilised its land for the option period with nothing to show for it other than the option sum. Typically, the option agreement will contain a mechanism for calculating the purchase price at the point when the option is exercised, usually at a pre-agreed discount to open market value at the time. With a promotion agreement, the promoter identifies land for development and will enter into a promotion agreement with the landowner, paying a small premium on completion of the agreement. The promoter has an obligation to try and obtain planning consent for the development. Promotion agreements are typically used where the land in question is not ripe for development in the short term. The promoter must use its expertise and money to promote the property in the local development framework. Then, working with the landowner, it must obtain a planning permission for the development that maximises the value of the property. Sometimes the agreement requires the promoter to carry out initial development of infrastructure, such as building the main site roads and services. The aim of a promotion agreement is to find one or more buyers who will build out the development once planning consent has been granted. Once the consent has been secured, the promoter doesn't purchase the property itself, but will market it and try to find a buyer. In return, the landowner agrees to sell the site to the successful bidder and agrees to share the net sale receipts with the promoter. The parties will agree in advance the proportion of their shares, which tend to be reflective of the level of risk that each has undertaken. This slide lists some pros and cons of promotion agreements. One of the main advantages of a promotion agreement is that, unlike an option agreement or conditional contract, the interests of the landowner and the promoter are aligned because both parties are keen to achieve the best possible price for the land. A promotion agreement enables the promoter to take advantage of any uplift in the value of the land if the planning application is successful, without having incurred the initial costs of acquiring the property and arranging finance. The landowner has the comfort of knowing that the promoter has an incentive to work to achieve the best planning consent possible, as it will receive a fixed percentage of the sale proceeds, as well as having its own planning cost reimbursed when the land is sold. In an option agreement, the pricing exercise is undertaken by negotiation and evaluation by referring to evidence of the local land market. Typically, the developer will want to pay as little as they can, whereas the landowner will want to maximise value. As such, this price negotiation can sometimes be a lengthy process. With a promotion agreement, the main challenge for a landowner is choosing a promoter who has the finances to take the land through the planning process, which can be costly. An important factor in promoting a plot of land can be proving the deliverability of a scheme to the LPA, and the promoter might not necessarily be best placed to understand what local developers are seeking. The risk here is that vast amounts of time and money are spent achieving a planning consent for a scheme that developers are reluctant to build. That might be because it doesn't meet the needs of the local market or because it's not economically viable. In those circumstances, partnering with a credible developer under an option agreement could prove to be more beneficial. Another con is that the landowner will not see a quick return. The promotion agreement is often a long-term agreement lasting for between 5 and 10 years. Securing planning consent under a promotion agreement is a slow process. Usually, the landowner will have to wait until a sale is secured to see any money, as the initial sum paid by the promoter is usually low. Contrast that with an option sum, which could be a significant amount. From the promoter's point of view, it must be able to trust the landowner. The promoter is the party paying money to promote the land through the planning process and must be confident that the landowner will continue to promote and develop the site and sell to the highest bidder when the time comes. When negotiated well, both types of agreement can secure a satisfactory outcome. The specific circumstances of the land, its location, local market characteristics and the planning legacy of the area should all be considered, which is why it's always sensible to seek professional advice as early as possible in the process. Thank you for listening. I'm going to hand over to Carly now to talk about the Building Safety Act.
Thanks, Sarah. Morning, everyone. So let's have a look at some of the key provisions of the Building Safety Act and how they're working out for us in practice. So the Act was brought in after the 2017 Grenfell Tower tragedy due to safety concerns for occupants of high-rise buildings. The Act aims to improve the design, construction and management of high-risk buildings and deal with how remediation costs will be met by developers, building owners or the leaseholders themselves. One of the key aims was to enable the owners of these affected buildings to actually be able to sell their flats. The Act works alongside other measures brought in following the Grenfell Tower inquiry, including the Fire Safety Act 2021, valuation guidance for high-rise buildings from the Royal Institute of Chartered Surveyors, and changes to the requirements of mortgage lenders under their handbooks. The vast majority of the provisions came into force from the 1st of April 2023. So let's look at how the Act applies in practice and the type of buildings involved and the type of work covered by the Act. So the Act applies to relevant buildings. That's defined as a self-contained building containing at least 2 dwellings, being at least 11 metres in height or at least 5 stories. So if you have a look at the diagram on the slide, the height calculation is done by discounting anything under the ground, then going from ground to the finished surface of the floor of the top storey of the building, and then the top storey itself and any rooftop machinery or any roof terrace is then discarded. So we've covered the building itself, and there also then needs to be a defect in the building which requires remediation. So the Act will apply if a person's safety is at risk from fire or structural collapse of a building due to the inappropriate or defective product use during construction or later work. The defect in construction must have occurred in the 30 years prior to the 28th of June 2022. So in order to rectify these defects, there are three classes of remediation. Remediation to aluminium composite cladding, or to non-ACM cladding, and ancillary remediation. So when we talk about ancillary remediation, that means remediation still in connection with building safety, but not relating to cladding. So this might be waking watch, where overnight security is needed to monitor fire safety until cladding is removed. It might be the installation of sprinklers as a protective measure, or it might be work to a balcony in order to reach cladding itself. So who pays for the remediation work depends on the size of the building and whether or not there is a qualifying lease. So there's a number of criteria to be met for the lease to be a qualifying one. So we need a long lease of more than 21 years of a single flat in a relevant building. The tenant must pay a service charge under the lease. The lease must have been granted before the 14th of February 2022. And then in terms of the tenant's circumstances themselves, on the 14th of February 2022, the flat was either the tenant's only or principal home. The tenant did not own any other dwelling in the UK, or the tenant owned no more than 2 dwellings in the UK, apart from this flat lease that we're talking about. So there's been a lot of commentary surrounding the assessment of what is a qualifying lease and the selection of the date of the 14th of February 2022 as the deciding factor. These circumstances could leave, for example, a first-time buyer in the position of not being a qualifying leaseholder, simply because they have purchased from a person who owned 3 or more properties on the 14th of February 2022. So who's responsible for the cost of remediating, and what protection does the Act offer to leaseholders? Well, for buildings over 18 metres or more, we can make a claim possibly under the Building Safety Fund. For buildings of 11 metres or more, you might be able to make a claim under one of a number of measures. So we've got the medium rise scheme, the developer remediation contract, and the caps and protections offered by Schedule 8 of the Building Safety Act itself. So we're not going to look at the protections offered by the various funding schemes and grants in this session, but we will look at the protection offered by the Act itself. So under the Act, the protections depend on who actually carried out the work and the net worth of the landlord. So where the landlord was also the developer of the building, or was responsible for commissioning work during the previous 30 years, leaseholders, whether qualifying or not, are protected against the costs of remediation, and that's both cladding and non-cladding remediation. So if the landlord was not the original developer, but the landlord's net worth on the 14th of February 2022 was more than £2 million per relevant building, then a qualifying leaseholder has complete protection against the costs of remediating both cladding and non-cladding fire risk. So then we go down to the situation where the landlord was not the developer and the landlord's net worth was less than £2 million. So in that scenario, a qualifying leaseholder has only limited protection against the cost of remediating non-cladding safety defects. And in that case, each qualifying leaseholder could therefore be required to contribute a capped amount towards remediation costs. So if we have a look at the caps in a bit more detail, nothing would be payable by a tenant where the value of the qualifying lease on the 14th of February 2022 was less than £325,000 for properties in Greater London and £175,000 for properties anywhere else in the UK. Above that, there is a permitted maximum contribution where a leaseholder would pay £15,000 for properties in Greater London and £10,000 anywhere else. These permitted maximums then increase for properties worth over £1 million and then another increase again for properties over £2 million. There are special rules for calculating the permitted maximums where there is a shared ownership lease. The costs under the caps do also include legal and professional costs and the cost of any required waking watch. And any charges which have been made to the leaseholder via service charge within the previous 5 years in connection with remediation can also be taken into account in that cap. So how do we pull all of this information together so that it can be provided when a person comes to sell or purchase a flat? Well, 2 certificates need to be provided to assess the position of the incoming tenant. So first we've got the landlord certificate. This contains all information needed to calculate how the landlord is entitled to charge for building safety work. Supporting evidence must be supplied by the landlord to evidence their net worth. The landlord must provide the leaseholder with this certificate at specified points. So when the landlord wants to pass on any remediation costs via the service charge, within 4 weeks of the landlord becoming aware of a relevant defect, or within 4 weeks of a request from a leaseholder notifying the landlord that their interest is being sold. So at a very early stage in the process, the tenant must notify the landlord that the flat is being sold and request that that certificate is provided. Where a landlord does not provide a certificate which complies with the regulations when requested, could result in the landlord not being able to recover a leaseholder contribution which otherwise they would have been entitled to recover. So then the leaseholder deed of certificate provides a permanent record as to how the flat was owned and occupied on the 14th of February 2022 and will identify whether the lease is entitled to protection under the Act. Similarly to the landlord's position, a leaseholder who fails to provide this certificate when asked to do so could lose valuable rights. If the current leaseholder wasn't the owner on the 14th of February 2022, then they are required to make inquiries of the former leaseholder to establish the qualifying status of the flat at that time. The certificate is a deed for the leaseholder and contains a warning that dishonestly completing it may be a criminal offence. The leaseholder must also provide evidence to support the responses as to how the property was owned on the 14th of February 2022, which could be produced via Land Registry Office copies, council tax invoices to show their ownership and occupation. So how is this actually all coming together in practice and what problems are we facing? Well, legislation is very new and ever evolving. As the Act is used in practice, there's a lot of commentary on the interpretation and intended meaning behind certain sections, and legislative changes are then being made. One example and one key change that required immediate review was the fact that a lease which had been extended in its term after the 14th of February 2022 under the original drafting of the Act was not then deemed to be a qualifying lease. Full guidance as to the interpretation of the various sections of the Act is still being drafted. Some law firms, although not Myerson, have made the decision not to undertake any work in connection with properties affected by the Act due to its complexity, its ever-changing nature, as well as the potential rise in insurance premiums for carrying out what is now deemed to be higher risk work. Mortgage lenders have varying requirements as to what information and documentation will satisfy them as to building and fire safety, some of which can be quite onerous. Landlords and management companies can be lacking in the understanding of what is required from them at the point of sale, and may also not understand the legislation and how it affects them and their building. Sometimes the party responsible for the building is not actually the person who will be completing the certificate. So for example, you could have a landlord who is legally responsible for the building, but has delegated day-to-day management to the management company. The landlord, when being asked to complete the landlord certificate, may not therefore fully know or understand the current status of the building and any possible defects, but then on the reverse side, the management company would not hold the information as to the landlord's net worth. So obtaining correctly completed landlord certificates during a transaction can be very difficult. Because so much information and documentation is required, and it can take time for the correct information to be supplied, this is ultimately having a knock-on effect on the transactions and significantly slowing down a sale or purchase transaction which is affected by the Building Safety Act. That concludes what I want to say about the Act this morning, and I hope you found it useful. I'll pass back over to Jo.
I think, as you say, lots and lots of changes and making transactions very difficult, very much a moving feast, which makes things even worse. So that's us finished with the presentation for this morning. As I said, please do stay around and have a coffee and another pastry. There are lots of pastries still next door, so please help yourselves. If there's anything you want to chat to us in more detail, we can arrange a meeting or have a chat now. If you're watching us online, please do get in touch afterwards. Contact details are on the slide. If you have any questions after the budget about the tax changes, we're actually holding a tax seminar. That's going to be in November. So the details are in your packs. They'll also be emailed to everyone who's watching online afterwards. And in case you want to watch again, we will be emailing you the link to watch this again. And it will also be on our YouTube channel, which we like to look at. So obviously, if you know of anyone who might be interested in the topics we've covered today, please do feel free to share that link with them. So all that remains is to say thank you very much again for joining us and enjoy the rest of your day. Thank you.